So good morning, good afternoon, good evening to all, according to the region of the world you're coming from. Allow me, on behalf of the Geneva Centre for Human Rights Advancement and Global Dialogue, and on my personal behalf, to warmly welcome our esteemed panelists and thank them for having accepted our invitation to this panel, despite their heavy schedules, in order to share with us their analysis and insights flowing from their remarkable expertise and hands-on field experience at the international, national, and local levels. I will be introducing each of the panelists respectively before giving them the floor. Let me also welcome the participants who I see are numerous and coming from all regions of the world. It is very encouraging to see your interest in this issue of vital importance for human rights. This is our Geneva Centre's third panel of this year. The first was entitled Defending Women and Girls' Rights to Education, Challenges and Perspectives. The second was on interfaith dialogue and reconciliation, creating and sustaining spaces of encounter. These panel publications can be found on our website. Organizing panel discussions on important human rights issues and publishing the proceedings, including lessons learned and recommendations, is part of our four-pillared mandate, which is research and publication as a human rights think tank, training and national capacity building in human rights, international advocacy, mainly but not only, mainly through reporting on major human rights developments and conferences, in particular the sessions, the regular sessions, and UPRs and special sessions of the Human Rights Council. And the fourth pillar, cross-cutting, is offering a platform for global, intercultural, interfaith dialogue on vital human rights issues, such as the present panel, precisely. I warmly invite you to visit our user-friendly website. Allow me now to present very briefly, given the expertise already present in the panel, the theme of this panel, which is surveillance technologies and human rights beyond the security freedom dilemma. Although they have great potential for positive impacts, surveillance technologies are sparking a debate that too often overlooks human rights considerations. From targeted use of spyware against journalists and human rights defenders, facial recognition disproportionately targeting minority communities, to the use of monitoring centers to nip protest movements in the bud, unbridled surveillance practices have shown to dangerously threaten the enjoyment of human rights. Most evidently, this results in the reinforcement of discrimination, including racial profiling, censorship, violation of individuals' right to privacy, abusive detention, torture, and so forth. Very recently, actually, I read this 3 days ago, the Human Rights Council appointed independent experts. They noted that urgent red lines must be drawn given the already alarming use of surveillance technologies and the growing concern for freedom of expression. These technologies, the independent experts said, are driven by small groups of powerful actors with almost no requirements for conducting human rights due diligence. The experts stressed that regulation is needed to ensure transparency and accountability, and that both industry and states must be held accountable. This panel will thus aim to, among others, identify international best practices and innovative ideas to tackle the impact of surveillance technologies on human rights, explore the broader impact of surveillance technology use on societies and identify specific human rights risks, bring a better understanding of the obstacles and contentions regarding use and regulations, and of course, that is also the goal, one of the main goals, formulate clear recommendations in regard to international law based on a human rights perspective. I will now open the panel, and I would wish to say that the time allotted to each speaker is a maximum of 10 minutes, as we have 4 eminent speakers. This would allow all panelists to make their presentations for an equal length of time and leave at the same time sufficient time for a Q&A session, thereby ensuring that the entire panel does not exceed an hour and a quarter. The full written contributions of panelists will be included in the publication of this on this panel event. Hence, the limitation of oral statements to 10 minutes maximum is an earnest request, and I thank you in advance for your cooperation, dear panelists, in this regard. Without further ado, allow me to call upon our first panelist, Mrs. Meredith Veit. Mrs. Veit, I hope I'm pronouncing it rightly in the German sense. Veit? Okay, sorry. Veit holds a master's degree in human rights and democratization from the Global Campus of Human Rights and a bachelor's degree in communication and public culture from the George Washington University. Her work sits at the intersection, that's very interesting, of business, human rights, and technology, with a particular focus on human rights risk groups. She also specializes in fact-finding, trauma-informed, and gender-sensitive interviewing and project knowledge. To make it simpler for me, I'll call you Meredith. Meredith, could you speak to us about, for example, how do surveillance practices have a disproportionate impact on vulnerable groups? Or what are some of the most effective tools to promote compliance with human rights standards within the private sector? And what do human rights due diligence processes entail for private actors? Meredith, the floor is yours.
Thank you so much, Dr. Umesh Palwankar and Iman and the Geneva Centre for Human Rights Advancement and Global Dialogue for inviting me to participate today. I have a brief presentation, which I think Iman is helping me to pull up, but I can get started just by introducing myself and the organization that I work for. I'm a researcher for the Business and Human Rights Resource Center, which is an international NGO that collects data on the human rights impacts of over 10,000 companies worldwide. We have a team of 83 members across 36 countries, engaging with companies and investors to urge them to share more information about how they're working to prevent and mitigate human rights harms and remediate where necessary. I'll be posting a bunch of links in the chat throughout to give you some more resources as I go along. Since the founding of the Resource Center about 20 years ago, we've made over 6,000 information requests across a number of sectors. And our website is a database where we collect allegations made against companies and their responses to those allegations. So we're building up a repository of information of allegations coming from civil society, investigative journalists, think tanks, and other credible sources, including sources coming from the Global South in multiple languages, related actions taken by the private sector, testimonials, and we're publishing analyses of trends that we're seeing across different industries to build arguments for materiality and material risk linked to human rights harms, which I'll talk about later, including in the surveillance tech ecosystem. So for the tech sector, what you're seeing now is an example of one of our tech company dashboards. So my colleagues and I are feeding information into these dashboards, which includes company and financial info, details of lawsuits over alleged human rights violations, available benchmarking rankings, including from Ranking Digital Rights, the Corporate Human Rights Benchmark, Know the Chain, and others. And this is where we collect the related allegations for each company and the most frequently associated salient human rights risks. And if we move over to the next slide, we're also tracking allegations against industry actors that are involved in the overall surveillance architecture, including internet service providers, telecommunications network equipment vendors, companies that are more exclusively engaging in the production and sale of surveillance and invasive tech like Spyware, including NSO Group, Finfisher, Gamma Group, for example. Companies providing a range of goods and services that include, but maybe are not limited to surveillance tech like Alphabet and Amazon, and companies that are producing goods and services that can be used for both surveillance and non-surveillance purposes. So these could be considered the dual use or legitimate versus illegitimate use of surveillance tech like Sandvine. And we're doing more work to better inform the investors that have surveillance tech companies within their portfolios about the affiliated salient human rights risks as well. So I'll talk about that soon. And if we can move to the next slide. So in particular, as was described in my intro, we're looking at surveillance tech's impacts on at-risk groups across a diversity of contexts. So for example, an investigative piece was recently published in the Washington Post about how public housing facilities across the United States and local officials within those communities are installing powerful and pervasive surveillance systems. And these are being funded through federal crime-fighting grants. But we're seeing that this is imposing an outsized level of scrutiny on some of the country's poorest citizens and disproportionately impacting minority groups. And some of these cameras are equipped with facial recognition and other artificial intelligence capabilities, but there's no guidance or limit on their use, and there's little evidence that they're actually making communities safer. Instead, the surveillance footage is being used to track minor infractions of residents, such as sharing your key with a non-resident or removing a cart from the communal laundry room to evict people. And one example within this context is a public housing community in North Dakota, where officials have installed 107 cameras to watch 100 residents, which is a ratio of cameras per capita similar to what you see in the infamous Rikers Island jail complex in New York. So these are kinds of inputs where we need to ask ourselves why this is happening and how these types of communities can hold companies to account. We can change to the next slide. Since the creation of the tech research team within the Resource Center, we've logged over 400 allegations of human rights abuse linked to surveillance tech companies. Other examples of database inputs that demonstrate the flawed security versus freedom dichotomy include cases in Iran where police are deploying surveillance tech to identify and prosecute women who breach the hijab law. In Palestine, we're logging the reports coming from Amnesty International calling out tech companies who are facilitating the implementation of the apartheid system. In Myanmar, where tech companies are allegedly helping the junta build an attack and surveillance infrastructure. In the United Kingdom, where the quote-unquote dystopian workplace surveillance system is disproportionately targeting young female and minority workers. In Egypt, where digital rights groups are getting more and more concerned over fundamental freedoms as tech companies are building up the new administrative capital, smart city. And of course, in Mexico, where there are instances of spyware and targeting of human rights actors, including most recently from the report of Citizen Lab, the person who's coordinating the work of the country's Truth Commission. So as you're seeing now, we also recently published a report highlighting the lack of human rights due diligence of tech companies operating in migration contexts. People on the move, particularly asylum seekers and refugees, are highly vulnerable to rights abuses linked to the irresponsible deployment of surveillance tech. And the Resource Center's briefing analyzes responses to a survey that was conducted on corporate transparency and due diligence processes of 24 companies, which have allegedly produced or provided surveillance tech to governments in the MENA region. And some of these companies include Airbus and Nexa Technologies, Cellebrite, IrisGuard, Thales Group. And at the end of the report, there are a number of recommendations for companies, investors, and governments. So I'll post this in the chat shortly for you to review later. And then lastly, on the final slide, I just wanted to highlight some of the work that we're doing relating to helping to translate all of these concrete cases of rights abuses, strategic litigation, regulatory enforcement, the creation of different export regimes, and overall public scrutiny into arguments for material risk that investors need to consider. So we recently released, along with a number of partners, a due diligence guide for investors on surveillance tech, which outlines the key human rights due diligence questions that investors need to scrutinize when they're looking at companies' governance, policies and practices, the product life cycles, and remediation work. And this is to identify whether a surveillance tech company may be a low, moderate, or severe investment risk through a human rights lens. So in the interest of time, I'll stop there, but in the discussion, I look forward to talking about additional avenues for corporate accountability, including governments carrying out their own human rights due diligence processes in their procurement and purchasing practices. And an example we can delve into perhaps is the US federal government's executive order on spyware, which the Resource Center and Unwanted Witness, who is another panelist here today, were involved in advocating for during the Summit for Democracy last March. So thank you for your time and looking forward to your questions.
Thank you very much, Meredith, for having so well set the stage for the ensuing panel discussion, for having kept the time limits. That's very good for me as a moderator. And thanks again for focusing also, bringing the focus also on migration and surveillance technologies. It's something that's pretty important, and I think it's being understudied, in my opinion. And indeed, in the end, as you said, the importance of due diligence. Thank you. I now call upon our second panelist, Allan Sempala. Is Allan Sempala? Can you hear me? Okay. Iman, is Allan Sempala?
Oh, yes.
Oh, okay. Sempala Allan Kigozi is a tech lawyer and a digital rights activist. He has been at the heart of campaigns that promote the right to privacy, free expression, both online and offline, and a strong enthusiast of internet governance. He's an expert on the intersection of technology, law, and human rights. Excellent for our panel. Sempala is currently the head of legal and programs at Unwanted Witness, where he has led advocacy campaigns, research interventions, capacity building workshops, and strategic litigation on the realization of human rights and good governance. So Sempala, welcome on board, and it would be very interesting for us to hear you speak on, for example, what are the risks for normal people regularly associated with surveillance on and offline? How can we ensure accountability and effective redress in case of privacy violation? What are the mechanisms, if at all there are any, that are in place? And how can civil society, private companies, and governments work collaboratively to respond to surveillance-related human rights risks? And whilst we are on this, what could we do? What steps could we take to enhance this dialogue, this tripartite dialogue? Sempala, please.
Are you hearing me? Am I audible? Awesome. I'll just give you a brief about Unwanted Witness. Unwanted Witness is a civil society organization founded in 2012. Yeah, we are making close to now 10 years in the field. So we were founded to promote online freedoms and protecting digital rights in Uganda. The aim of this organization is essentially to create a safe and secure digital environment for citizens and to promote responsible use of technology. Now, heading very fast with interest of time into your question on surveillance and how it has effects on people. So surveillance, both online and offline, carries several risks for regular people, and there's several risks that are associated with it. One of the most important and what we need to put our focus on is invasion of privacy. Surveillance can lead to a significant invasion of privacy. It allows others, to access your information, monitor it, monitor your activities, and the communication you have with others, and without consent. Now, this intrusion into privacy life or private life of someone can have emotional and psychological, consequences on citizens. The other challenge that surveillance has on and the issue related to it, the risk related to it, is data breaches and identity theft. Surveillance systems may store a vast amount of data, of personal data, making it target potential, making it a potential target for hackers. Hackers, once you have all this system and data centered around, it's very easy for them to hack into it. It's very common in Uganda where telecoms are hacked into. Telecoms in Uganda, share a lot of data with the National Identification Authority, the authority that is responsible for registering and giving national IDs to citizens. Now, they share vast amount of personal data with the telecoms, and they've been a target of hacking. And this is not unique to Uganda, but in several countries, we've noticed that many of the telecoms, or even the national registers for national ID, have been hacked into. So if these systems are compromised, individual sensitive information such as financial details, passwords, social security numbers, can be stolen and can be misused for theft, especially identity theft and fraud. The other issue is the chilling effect on free speech. Once you're surveilled, the knowledge of being under surveillance can have a chilling effect on how you express yourself. It's common that the more your privacy is infringed, you're surveilled, then it has an effect on how an individual expresses themselves. So individuals usually fear to be censored. Opinions and activities of these opinions are usually in a way they are affected. People can't freely innovate, can't freely express themselves, and the fear of potential repercussions. This has in a way stifled creativity and innovation, and of course open discourse, So the other effect that we could have with surveillance, ladies and gentlemen, is the reputation damage. Much of this information, collected under surveillance, in a way has been used against, especially government, workers or political leaders. For instance, in Uganda, this information has been used, collected, and has been misused and has leaked, which has caused reputation damage. And this has not left them, the way their image the same. So pretty much those are the risks that that come with surveillance. You mentioned of accountability and the effective redress in the case of privacy violations. What could be the mechanisms that we could use to probably in a way deal with the risks that come with surveillance? Of the opinion that if you have strong privacy laws and regulations, then you can be able to at least manage and regulate and supervise the use of that personal data. I really think government should establish robust privacy laws that are clear and define individual rights and organizational obligations. But most of the countries, of course, in Africa, we have several that have registered and have had the opportunity to have laws. But these laws have glaring loopholes, and data collectors have used these loopholes to go around, and utilize people's data without accountability, without any sense or due regard to the privacy of the data subjects. We also need independent data protection authorities. When you have an independent data protection authority, it's very important that you have one. And when you have one, then you are sure that once data is irresponsibly used, then those who are using it wrongly can be able to face the law. So government should establish independent and empowered data protection authorities responsible for enforcing privacy laws. And these should, be able to investigate, conduct audits, and impose penalties, for non-compliance. I think they should also provide guidance to organizations, individuals on privacy-based practices. Once you have those independent, then you are guaranteed for an effective redress. Now, that is rare in Africa because many of the DPAs or data protection authorities are not independent. They don't have the financial budget. They don't have resources to actually monitor and regulate the use of personal data. They are under-resourced, yet the people who use and manipulate personal data are so influential, very powerful, and very resourced. So it makes it very easy to go around these DPAs, and in a way, many rights are infringed because of the weaknesses there is in the DPAs. Certainly, we need transparent privacy policies. We need organizations that collect this mass data to have privacy policies that are transparent, because many times organizations preach one thing in their privacy policies and actually do another. So we need privacy policies to maintain transparent and easily understand exactly how they collect, they use, they share personal data. So these privacy policies should also provide information on individual rights and the procedures to file complaints or seek redress in case of any privacy violations. Certainly, informed consent is one of those. Data minimization and purpose limitation is one of those. But also, most importantly, there is the security measures. So for us to be able to in a way mitigate the risks that come with surveillance and collecting of massive data, whoever collects this information should have sufficient security measures to protect this information. Currently in Uganda, we have several telecoms collecting this data, and yet their security measures are very weak. So it's now common knowledge, and on a daily basis, their systems are hacked into. People's information is shared with third parties without consent. People have lost money. People have lost reputation. People's businesses have gone down because of the weaknesses in security measures and lack of proper way of doing, notifications in case of any breach. And lastly, we definitely need public awareness. This is what Unwanted Witness has been doing for quite some time. We try to create as much awareness and campaigns and program and education programs to make sure that people understand the obligations, those who collect personal data, but also individuals could be able to make informed choices and encourage a privacy conscious culture. I don't know if I still have time, but I could be able to share more once I'm given an opportunity to share how exactly we can mitigate effects that come with surveillance.
Thank you very much, Sempala, for both your very interesting contribution to this panel discussion. Among you addressed so many points, among which privacy policies, redress procedures, and also the need for public awareness. I think if you remember, I mentioned that one of the things Geneva Centre, the think tank, does also training and national capacity building and international advocacy. So this is a very important aspect of the work in a domain as technical, especially in a domain as technical and complex as this. And I said for both contribution and also your truly praiseworthy efforts in the field in relation to this complex domain. Thank you again. With that, I have the honor to call upon our next panelist, Mrs. Tamar Kaldani. Tamar holds LLM and MBA degrees. She's a certified information privacy professional Europe credential from the International Association of Privacy Professionals. From 2018 to 2022, 4 years, Tamar served as the first vice chair of the consultative committee of the Council of Europe Convention for the Protection of Individuals with regard to automatic processing of personal data, Convention 108 as it's known. As Georgia's first data protection commissioner, she established the independent supervisory authority and developed it 2 consecutive terms from 2013 to 2019. And since 2019, as an expert of the European Union, Council of Europe, World Bank, the UN agencies, she has contributed to the development of data protection legal frameworks and supervisory authorities in 7 African countries, 3 Central Asian republics, 2 Eastern European states, and the list is long. So Tamar, great to have you here. And could you enlighten us with all this knowledge and expertise that you possess about some issues such as how does the COE Convention 108 and other international legal instruments permit restrictions on individual rights to privacy and data protection for the sake of national security? And what gaps or inconsistencies do we have to work in this regard? How can the international community at large take action to protect the fundamental rights of people living in domains, in regions that do not afford sufficient human rights safeguards on the use of such technologies, and perhaps what initiatives are underway to be able to reverse this? Tamar, you have the floor.
Thank you very much for the invitation. I hope you can hear me well. Indeed, the government and private companies across the world are investing significant resources in developing and deploying surveillance technologies. AI is being increasingly implemented in this market, and I was checking recently the data from Statista, and it seems that the global surveillance technology market was valued at over $130 billion last year, and the annual growth rate is 14-15%. The revelations and some practices disclosed so far, and I believe this is only the tip of the iceberg, and the examples that was shared even by the first speaker raised legitimate concerns about our privacy and other fundamental human rights. We as a civil society and citizens are also concerned with the reliability of and security of those technologies. As we all know that even very progressive and useful innovations are accompanied by some risks, and if not regulated and managed properly, the mass surveillance technologies and predominant nature of AI systems with all these predictive and tracking abilities can significantly affect our fundamental human rights. Yes, we all acknowledge that concerns about national security and criminal activities may justify the use of surveillance technologies. Intelligence and law enforcement services could have the legitimate aim to obtain the necessary information swiftly, like using interception or facial recognition systems, or using AI's predictive ability to prevent crime or combat the threats related to national security. However, this is very important once again to state that even states' wide-ranging discretion in the area of national security is not uniformly broad, and states are bound by international, regional, and national human rights instruments. So they have negative obligations as well as positive obligations to safeguard individuals, including from the actions by non-state actors. Therefore, human rights should be at the center of any discussion or decision-making related to surveillance technologies. At the Council of Europe level, Article 8 of the European Convention on Human Rights, relevant jurisprudence of the European Court provide clear guidance and interpretations regarding the possible restriction of the right to privacy. First, restrictions should be provided by precise, clear, accessible, and foreseeable laws. The development of surveillance methods or technologies, especially resulting in masses of data collected, must be accompanied by a simultaneous development of legal safeguards, seeking respect the essence of the fundamental rights and freedoms, And to make sure that interference with the right to privacy is necessary in a democratic society, states have to demonstrate proactively the legitimacy, necessity, and proportionality of the surveillance with regard to legitimate objectives that should be in direct connection with the pressing public needs, including public safety and crime prevention. European Convention, European Court judgments, resolutions of the Parliamentary Assembly, including 2045 resolution on mass surveillance, recommendations of the Committee of Ministers provide the legal instruments to ensure this. Moreover, Convention 108, which is a landmark instrument since 1981 and the only legally binding international treaty in the data protection field, ratified by 55 parties, including 9 non-Council of Europe member states, set the basic principles for data protection, safeguards for individuals, and supervision over the data processing operations, including surveillance, to deal with the challenges of modern data-driven and digital world. Modernized Convention 108 Plus reaffirmed the importance of these original principles and laid down the new ones, including transparency, accountability, privacy by design, and the need for human rights and privacy impact assessments that are particularly relevant in the context of surveillance technologies. And the convention also provides individuals with strengthened rights, including in automated decision-making or profiling contexts. It is important to recall that, contrary to previous provisions of Convention 108, parties to the modernized convention will no longer be able to exclude from the scope of application of the convention certain types of processing, such as for national security or defense. The possible exceptions to a limited number of principles, such as transparency, are subject to special conditions, and in any case, independent and effective review and supervision should be guaranteed. Modernized convention also reinforced the investigative and corrective powers and independence of data protection authorities and enhanced their international cooperation and opportunities for joint action. And the level of transparency and public scrutiny in the application of surveillance technologies are still limited. Data protection and other regulators and independent and effective supervision, I believe, plays a critical role in building trust and balancing interests at stake. Council of Europe Convention 108 Committee, I was vice chair of for more than 4 years, offer also various practical guidelines that are particularly relevant in this context. For example, guidelines on AI, facial recognition, or practical guide on the use of data in the police sector. And there are a set of guidelines that address also developers, manufacturers, and service providers. And those guidelines are more focused on accountability of the companies, quality of data and algorithms, and reliability of the tools used. Also those guidelines emphasize the role of different actors, including civil society, that have to ensure the protection of our rights and fundamental freedoms and prevent dangerous outcomes, both at individual and societal level. And the last point I wanted to address during my intervention is that people embrace data-driven innovations and technologies only if they're confident that their data are processed in a lawful, fair, and proportionate manner. Therefore, effective safeguards and credible oversight systems should be in place to enable the identification of unlawful activities and ensure that those responsible are held accountable. Transparency and accountability creates a foundation for trust, and along with compliance with data protection legal frameworks, self-regulations, code of ethics, certification mechanisms could also help to enhance this trust. As the inventor of World Wide Web, Tim Berners-Lee once said, we cannot blame technologies when we as humans make mistakes. So this is really our job, the job of civil society, decision makers, regulators, ordinary citizens, to make sure that the design, use, and technical standards of surveillance technologies are considered fully fundamental human rights compliant, and the legal frameworks that we develop provide strict safeguards against misuse, bias, discrimination, and also ensure the strict oversight. Allan just mentioned and addressed, and I'm very happy for that, the role of independent supervisory authorities. Yes, indeed, they should have powers, corrective, enforcement, and investigative powers, and they should have resources to exercise and supervise the implementation of data protection legal frameworks effectively. They should have also resources and capacities for awareness raising and to be part of all discussions related to important, let's say, technologies that affect the whole society, and they should be consulted prior of deployment any mass surveillance, let's say, technology. Obviously, they are the ones that should look into the implementation gap that exists in the law on paper, between the law on paper and reality on the ground. And really, I fully agree that empowerment of independent authorities is a crucial point, and the sanctions and remedies should be also effective, proportionate, and dissuasive. There are many I would say promising developments, that at the Council of Europe level, as well as at the EU level, there are discussions and attempts to come up with the solid legal framework on AI. There are a number of other initiatives. GDPR has a very positive effect on development of of national data protection laws. According to Professor Graham Greenleaf, by 2023, there are 162 countries with data protection laws and 70 plus with data protection bills. Most of these laws and bills are really modeled after GDPR and Convention 108 plus. So there are positive developments, I believe, also for global convergence, because privacy is a fundamental human right, and no matter where our data is processed, we have to have the right to benefit from the same level of protection. And I think the role of supervisory authorities, convergence, and cooperation between those authorities is crucial for ensuring that. Thank you.
Thank you so much, Tamar, for this very rich contribution, in which, among the several aspects of this complex theme that you have addressed and analyzed, you brought out the sub-theme of this panel, which is the security freedom dilemma. That's why we put it as that, and bringing out really the need for transparency, accountability, and oversight in this regard. And I was very glad you mentioned of all actors. It's not always the states or industries, also civil society. And it's very critical for trust building, true trust building. Otherwise, there is really mistrust and you don't know what's happening, who's doing what. So I think it's very important. And indeed, at the end, actually what happens between legislation, the law, and its implementation, reality, as you correctly put it. So thank you very much for that. I now have the privilege to call upon our final panelist, Catarina Fontes. Dr. Fontes holds a PhD in urban studies from the New University of Lisbon and the University Institute. She is a postdoctoral researcher at the Technical University of Munich. She was directly with Christoph Ludge, professor and director of the TUM Institute for Ethics and Artificial Intelligence. And one of her research topics is the use of intrusive surveillance technologies such as face recognition and other biometric identification systems in public spaces and impacts for individuals and society. So, Catarina, I believe we could greatly benefit from your ideas briefly in the time that is left. How does the increase of surveillance practices impact societies at large, and in particular, perhaps social behavior, interaction in public spaces? And to what extent the ways in which personal data is collected, processed, and used can be tailored to maximum protection for individual rights, and how are responsibilities for data protection distributed? And naturally, is there a need for a better balance? Very general question. Over to you, Catarina.
Thank you very much for the invitation and also for the questions. I mean, they are quite big ones, and I will try to touch upon all of them, but I'm sure we will not have enough time to dig into that in the way I would like to. Maybe if someone can help me with my presentation, because I prepared a few slides. Thank you. All right. So I guess it's a very diverse panel we have here, and actually I come from the academia, so I think I will have to talk about our research project. But I mean, I will not introduce the research project. I will just go into some of the insights. I don't see the presentation. Is it working, the presentation? Okay, Ben, I'll just start. So I would say that we are gone, the days that the image of surveillance for watchtowers are officially gone, and also CCTV cameras spread across urban neighborhoods are not anymore the most ubiquitous way or means to orchestrate surveillance. And maybe already next slide, please. So actually, not only our footprints in the physical world can be tracked, but also our digital footprint in the cyberspace, traces of our online presence, is under surveillance with or without us being aware of it. How artificial intelligence affects surveillance and privacy, leveraging data, namely personal data, became a very pressing matter for individuals and society. Maybe next slide already. So I would briefly talk about our research project that looks at the implementation of remote biometric identification systems by public authorities in public spaces and for law enforcement purposes. And here I would like to start by saying that even if human rights are definitely a baseline to discuss surveillance and privacy issues, I would say that we should move the discussion beyond human rights also to talk about the ethical development and implementation of such systems to make sure that they align with democratic values and that we can protect our democracies from such systems. So maybe the most well-known among these systems, the biometric identification systems, is the face recognition system that has already been trialed within and outside Europe and followed by significant backlash from civil society organizations and also activists. In response, actually many cities banned the use of this technology, and at the EU level, as we heard, there are significant efforts to regulate the implementation of remote biometric identification systems in publicly accessible spaces, as it is considered that it contravenes the EU values. So yes, technology keeps pushing the boundaries of what society thinks it is acceptable. But why do remote biometric identification systems might not be acceptable nor desirable in public spaces in order to support the enforcement of the law? So I will briefly talk about this topic by mentioning or by bringing up three of the many aspects that we could talk about. So first, it challenges the principle of fairness. Namely, it will be overexposing certain vulnerable groups to surveillance, by be they children playing in the public park, people living in the streets, street vendors, street artists, among many other groups. And also by scrutinizing access to public spaces. Indeed, it means that refusing being under surveillance in public space might become equivalent to giving up access to it, This contravenes the inclusivity of public space, potentially promoting the exclusion of groups particularly exposed or vulnerable to surveillance. And next slide, please. So second, it challenges the principle of autonomy. We are already assuming that there is a certain level of transparency from the public authorities when implementing such systems, yet we move beyond that and look whether autonomy can be safeguarded without questioning consent as one of the core topics. So consent actually goes beyond awareness. It's not enough to being informed about it. It implies an action of agreeing and simultaneously creating a path to withdraw. Also, if the values at stake are presented as unquestionable, the possibility of a diverse opinion is conditioned and the autonomy to make an uncoerced choice is hindered. So if a technology that relies on the intrusion of individual privacy is presented by public authorities as the most suitable solution to societal problems, such as criminality or terrorism, the request for consent is blurred by the apparent lack of arguments to decline it. And next slide, please. So third, and finally, I would bring up the principle of non-maleficence and talk about potential abusive and misuse of such systems. So there's the risk that mass and automated surveillance will be naturalized. And this may radically affect the way societies function and potentially undermine democracies. Naturalizing the use of intrusive surveillance systems can create a chilling effect, leading us towards coerced societies with individuals having their rights and autonomy suppressed. So to prevent the banalization of the adoption of intrusive surveillance systems and abusive use of personal data, there is the need to raise awareness of public authorities and populations about the benefits, yes, but also the threats that these systems represent, while empowering both to be able to discuss trade-offs. So there would be much more to say, but I think I will leave it like this for now and look forward to the questions.
Yeah. Thank you very much, Catarina, for this very interesting expose and keeping the time limit. So that leaves us good time for some question and answer session. I particularly appreciated the fact that you highlighted beyond the human rights stricto sensu perspective, the ethical aspects and the protection of democracy. I think that is an overarching framework within the team of this panel. So it was very interesting that you brought that out. So thank you, dear panelists. I think we can open the Q&A session. And I have some questions. All right, let me begin with one. I have a question or two for each. One question for each, basically, given the time. Also, is that Tamar, could you? Why is international cooperation in the field of cybercrime and data protection so crucial to protecting the rights of peoples? And what are the main obstacles to getting this legislation comply with international law?
Thank you. Indeed, cooperation is essential, and when data flows have no geographic boundaries, national or regional solutions are important but not sufficient. So this is, for me, the main point. And I have seen, as a first data protection commissioner for Georgia, with no leverage over multinational companies, I had to deal with a number of cases where I had to use cooperation platforms and bilateral formats to ensure at least some remedies for the individuals affected. And let me be quite honest, we were not always successful in our endeavors due to the differences in legal systems or limited abilities to obtain the necessary information in a timely manner or conduct joint investigations with other regulators. Besides the very important policy work carried out by the European Data Protection Board, Global Privacy Assembly, and other regional networks of the data protection authorities, like in Africa or Ibero-American network, we see now the clear focus on the practical and more pragmatic sides of cooperation, which is mutual assistance, joint investigations, and enforcement. And these discussions that we're observing are quite promising, and but obviously much more can be and needs to be done in terms of developing practical instruments for stronger and swift enforcement and close cross-border, let's say, cooperation of the authorities. And another important point is that we really need convergence between different legal regimes, because this is very crucial. As I mentioned, the privacy is a fundamental human right, and no matter in which jurisdiction my data is processed, I desire the minimum safeguards, right? And that my data should be processed lawfully, proportionately, and this is very basic. In addition, unfortunately, those revelations that we all see concerning the surveillance technologies, they also show that people that have nothing to do with any type of criminal activities and wrongdoings, they're subject to constant, let's say, monitoring, including like their behavior, their communication. And this, we have seen many scandals related to unlawful data processing of politicians, human rights defenders, activists, lawyers. And besides the direct effect that it has, there's illegal practices on those people who were targeted, we have to think about the chilling effect, as it was rightly mentioned, on the billions of ordinary citizens who live in constant fear that their communications, images, locations, movement, interactions are under constant, let's say, monitoring, right? This is really very important in terms of our other fundamental human rights. It's not only about the privacy, but it's about our dignity, our other essential human rights, including freedom of expression. That's why I think that this that there is a need at the regional and international level to agree on commonly acceptable standards. I believe that Convention 108 plus, modernized convention, really creates this ground for to be seen as a global, let's say, standards. And let me also highlight that there are 55 parties, as I think I already mentioned that. Out of them, 9 are non-Council of Europe members, and more countries could be invited and consider this convention as setting the minimum and basic standards that will be commonly acceptable everywhere. With regard to cyber crime, as you know, there is a Budapest Convention on cybercrime, and there are also very promising facts. If I'm not mistaken, more than 65 countries, 68, I guess, are parties to the to this convention and its protocols, and then 20 more either signed or are invited to accede to this international instrument. And I believe this also creates this common ground for convergence as well as cooperation. But the cooperation has very practical aspects when it comes to the data protection authorities, and cooperation has also different dimensions when it comes to the effective safeguards and addressing the common challenges, including in the field of cybersecurity.
Thank you, Tamar, for this comprehensive response. I now turn to Catarina for a question. Could you, Catarina, briefly speak about what aspects should be considered when deciding upon the adoption or authorization of surveillance technologies, including those using AI-enabled systems?
Well, again, surveillance technologies can mean a lot of things, and also we have to see who is putting forward this kind of initiatives. If it's public authorities, they have specific purposes. So I think it's always very important to think about who is doing it and for what purposes has it been implemented. Because we also know that, as I briefly mentioned during my my presentation, that surveillance has other phases that are even more obscure than what we see nowadays with, for example, facial recognition in public spaces. And these are even more concerning for me because awareness and transparency are completely not there. So yeah, I guess there are many angles that we need to just identify and tackle when talking about surveillance technologies, and not putting everything in the same at the same level or in the same bag, because risks are different and also benefits are diverse. So they should be assessed within this way. But I could talk about the case of the face recognition or other biometric identification systems used for the purpose of the prevention of crime. Still, in this case, I believe that they are presenting very high risks for democratic values and also for the individual rights, because, as it was mentioned, this is overexposing all citizens to this kind of surveillance, independently of them being under suspicion or not. So it's not that we are just tracking criminals, we are monitoring all citizens for no justifiable purpose. And this is something that changes the way societies live, because we don't live under this pressure that we are being monitored in public spaces. And if we are under this kind of premise, I think there will be this naturalization of surveillance that is quite dangerous for the prevailing democratic values, and it can lead actually to, it more links to authoritarian regimes.
Thank you very much, Catarina. Sempala, if I can turn to you. There's a question from the floor also. Can you elaborate briefly about the loopholes present in data protection laws and how they have been exploited?
Thank you very much. Certainly, I will talk about the loopholes in majorly Africa, the loopholes in data protection laws in Uganda, in Africa, but specifically in Uganda. The data protection law that we have largely in Africa was gotten from the GDPR, and not so much context to the African continent was context to the African continent, African context was put to the laws as they were implemented in Africa. So many of what privacy, much of what privacy means in Europe is not what it means in Africa. So, for instance, I'll tell you, in Uganda, there is no proper distinction and knowledge of what amounts to, to a data collector. So anyone can easily, be a data collector. You are at the same level as a telecom. You are the same level as, because if you collect phone contacts, like personally, I have a phone which has phone contacts. The laws, many of the laws in Africa, refer to me as a data collector. So on that note, I will be required to have a certificate of registration. I will be required to pay money, for getting the certificate. So with the laws that are not so comprehensive, it has been so very easy for manipulators and even government to use it to surveil citizens. For instance, governments have what they usually call national security. They can access, they use that, that leeway of collecting your data or processing your data, and sometimes they refer to national security. Now, this vagueness and ambiguousness of this law or that section of national security makes it very easy for government in any way collect your personal data without even your consent, without your knowledge. They will collect it and go and access it and process it in a way that even if it's not fair. So there is no guide, or there is no guidance on what exactly national security means, because it now gives a lot of powers to enforcement. So anything, even if they need you to submit some information, they will hide under national security. You know, many of the laws don't have regulations that enforce that law. So it would be very easy if we had regulations that speak to national security. It would be very easy for us to know where does national security start and where does national security end. Otherwise, the way it is in most of the African countries with data protection laws, governments can easily, you know, go ahead and collect massive data. I'll give you a case in point in Uganda. Currently, we have the National Identification Authority, the agency in charge of collecting mass personal information for purposes of ID in Uganda. It's now sharing this massive data with telecom companies. Much as there might be a benefit with sharing this data with telecom companies, such as easy identification, but the risks associated with that data are very huge. They do this without a privacy impact assessment. They do this without, you know, proper transparency on what this means. For instance, do these telecom companies have sufficient security measures to collect, to store and process this information? Because there are already precedences where telecom companies in Uganda, and this is true to also other African countries, that have been hacked into. Now, a telecom company accessing ID information, now there you get complete profiling of individuals, eroding them of their privacy entirely, because now they can be surveilled against, they can be monitored, they can monitor their movements and activities easily with information from the telecom and national ID, biometrics, location. That's complete profiling. So you see the risks that come along with government hiding under national security. So is the punitive measures that these laws have. The laws are not as punitive. So these people who utilize personal data are so resourced that the punitive measures that are put in the laws are not scaring them at all. In Europe, when you look at the GDPR, General Data Protection Regulations, their sanctions are a bit high. So it makes someone think twice before they want to infringe or use personal data of someone without their consent, or even manipulating it. In Africa, it's the different. It's the opposite. It's totally opposite. That the laws are not as punitive. You have DPAs that are not as independent as they ought to be. You know, for instance, in Uganda, the DPA in Uganda has almost 6 staff members. Now, 6 staff members to supervise the entire country, that's almost insane. It's unbelievable, you know, and next to very impossible, by the way. So such loopholes in data protection laws has made it very easy for governments to do massive surveillance and profiling of its citizens.
Thank you very much, Sempala, for that very informative response. I come from the floor, the last question from the floor addressed to Meredith. Could you very briefly tell us something more about the new Intelligence Authorization Act and the new US executive order on spyware, and what has been gained through these bills? Over to you, Meredith.
Thank you so much. And I'll comment on this and then also try to quickly address the questions from Suli in the chat. So the executive order on spyware from the Biden administration that was published in March of this year is, although it has significant carve-outs and gaps in terms of enforcement, given the nature that it's an executive order that only applies to federal agencies, and the fact that there are carve-outs for national security, this is one of the most advanced and promising developments in relation to accountability of spyware technologies and surveillance tech companies. And one of the most promising pieces of this is that there was an active engagement across multiple agencies within the US government, which is not always a given because the US government is not a monolith of actors. And they were actively engaging with other allied governments in order to sign on to similar human rights due diligence-esque practices in trying to identify which companies are affiliated with human rights harms, both domestic and abroad. It is to be determined how well this is actually going to be implemented, and it's not exactly clear as to how transparent the processes or results will be. But in such an opaque space, such as the proliferation of spyware, this is a promising development, hands down. And Business and Human Rights Resource Center was involved with a number of other actors in order to raise the concerns ahead of the Summit for Democracy, with over 40 other digital rights groups from around the world, talking about how we need more coordinated action. The surveillance technologies really are incurring borderless problems when it comes to human rights harms, especially for vulnerable groups, and need more scrutiny for investors. And we need to be able to more clearly follow the flow of money for who is investing in these surveillance tech products and how they're being developed. And we need more of an emphasis on know your customer due diligence and scrutinizing the end use of specific technologies, which is something that is now currently under deliberation within the Corporate Sustainability and Due Diligence Directive in the European Union. And I can post a link in the chat to a very great comparative analysis of how the Sustainability Directive, the CS3D, has evolved as it has gone from the Commission and now to the Parliament, and what are the critical things that civil society is pushing for. And when it comes to corporate accountability for the tech sector, we are very happy to see that there is a stronger focus on stakeholder engagement, which is something that another panelist had brought up before about Mr. Kigozi, about the need for there to be greater engagement between the impacted groups, especially groups in the Global South who are being victimized by some of the technologies and the tech companies that are being developed in the Global North. And there's also discussions now about what investors' roles should be in this. And I can post another really great article in the chat that dives into why we need to be considering investors as critical actors in corporate accountability, especially with tech, but how, unfortunately, due to some lobbying efforts, there have been more questions than there should be about whether or not investors are companies or firms that have influence within this space. And just to answer Sungli about kind of the resource center process, about how our company response mechanism works.
Meredith, if I may, could you wrap up fast, because we're getting to the end. There's one more question, so if you could please wrap up.
Sure. And then looking at the quality of information from the companies, I just invite everyone to have a look at the database, because you can see our timelines where we log everything into stories. The way that we source information is through our partners that are distributed around the world. We specifically look at local and regional CSOs and journalists and think tanks that are involved in conducting a lot of this research, including we publish reports from academia. So if you or your organization is working on raising the alarm about surveillance tech issues, please feel free to reach out, and we're happy to log your work in the database. And we use these third-party reports as a way to reach out to companies when companies are not responding to those groups. And so acting kind of as this intermediary, we're more able to pull their responses into one place, publish them in full so that the companies are having their voices heard, so to speak, in comparison to the allegations. But then these are public documents that CSOs can use also as a way to build further campaigns and advocacy work, and it can be used as evidence if there are any cases that are brought forth and related to these allegations. And I will leave it for you as the audience to have a look and see what you determine to be the quality of the responses from some of these companies. It varies across the board. Sometimes we get 1 or 2 sentence replies. Sometimes we get 3-page explanations with links. So have a look, especially if there's something that you're interested in, or if you have additional questions, please feel free to reach out.
Thank you very much, Meredith. There is a last question from the floor addressed to Catarina, but given the time limits, Catarina, if you could be really brief so that we can wrap up and end the panel. There's a question that says, are there any specific recommendations regarding the use of multimedia tools that enable biometric recognition and hence subsequently potentially put at risk some stakeholders concerned by some organizations? Very briefly, Catarina, over to you.
So I did not have the chance to explain how these biometric identification systems work with AI, but actually it's quite a simple process. They usually governments have some watch lists where the list of suspects that should be tracked are within this list, and then the images that are recorded in real time in public spaces are scanned with the help of an AI, and it identifies, so does the match with this data set or this watch list. So I am pretty sure there's ways to conduct this, use the same kind of technologies and systems with a video recorded as this Zoom meeting. So I would really recommend, I sympathize with your concerns, and I would really recommend that also about how to keep this data safe and how to store it in a way that it can be protected from being hacked or being accessed by other counterparties. I mean, this is really a huge topic, and I guess the best way to protect these persons is not recording their faces. Well, I would say this.
Thank you very much, Catarina. With that, I can end by saying that the Geneva Centre and myself, as moderator and as its executive director, thank the esteemed panelists for their very valuable contributions, and also the numerous participants from all over the world for their high interest. This would, I'm sure, go a long way in implementing all the rich ideas and recommendations made here. The Geneva Centre will issue a publication on this panel event, which will include a lessons learned and ways forward chapter. And as I mentioned before to the panelists, to enable a speedy publication, we thank you for submitting, who have not yet done so, your written contributions in full for them to be published. We are also happy to announce that the video of the event will be available shortly on our website and on social media. Once again, a heartfelt thanks to you all, and wishing you all success in your praiseworthy endeavors throughout the rest of the year, and also a lovely summer. Before we close the